So now I take this opportunity to introduce speaker of this session, CS V. Raghuraman ji. Mr. Raghuraman is a BCom graduate and he also is a chartered accountant and has also done CS ICWA LLB, and he was the rank holder in all his CA and ICWA and also in BCom. Mr. Raghuraman is having the experience of 30 years of practicing in the field of GST, excise, service tax, and foreign trade policy. And he is also the visiting faculty in the IIM Bangalore and ICAI. He is the regular speaker at the various forums and has published several papers in the national level magazines. He was the member of Indirect Tax Committee of ICAI for the year 14-15 and had authored many books related to indirect taxes. Sir, I, on behalf of the Guwahati branch of ICAI, welcome you to this virtual CP program. So very well, welcome here. Now with this, I request you to enlighten us with your knowledge and thoughts on the today's topic. Welcome, sir.
Welcome. Thank you very much. I thank the Gauhati branch for inviting me for this litigation-based seminar, as I would call it. It's a very unique program designed. I had the benefit of also listening to Mr. Shailesh just before me and his erudite lecture for some time. What I will be taking here is the legal maxims and the recent decisions which have come in the field of GST or which may impact GST. So I will, before I start, of course, my association with the Gauhati branch has been quite a very long period of time, more than a decade. I think I have come at least on 6 occasions or 7 occasions to Gauhati. I've had the benefit of seeing goddess Kamakya for at least 6 times, which is some sort of, I would say, spiritual record, I would say, for me at least. And I'm told it's a very auspicious thing, and there is no doubt that she has been guiding us to all these kind of seminars and knowledge sharing. And if repeatedly Gauhati has called me, it is because of her blessings. Coming to the subject, what I will do first is to deal with the legal maxims and then try to connect it with the GST subject rather than, talk of it in abstract. Now, some of the maxims I've chosen may be common, some may not be common, but I will try to dispose it off within the next 20 or 25 minutes so that we can go ahead and see the decisions which have been rendered in the recent past on GST, what I felt were the important decisions in GST. The first legal maxim that I would be dealing with is called actio personalis, moritur cum persona. That means a personal right of action dies with the person. Now, many of the laws in excise, in customs, where this maxim is applied is, can the liability to tax fasten on to the successor, legal representative who takes over the business? Can it be fastened on to him? If you look at Shabina Abraham's case, Supreme Court said in Central Excise, it cannot, because there is no provision which allows a successor to meet the liabilities of the predecessor. What is the impact of that? Shivkumar ji can mute. Thank you. So what happens is, if I have a liability and let us assume that I am succeeded to business by somebody else, can he be personally held liable? Can the department proceed against him? These are the questions that come up. And if you look at the GST law, they have plugged it. There is a section on liability itself, which makes the successor, the legal representative, liable to the tax. You see section 93, for example. Legal representative will be liable for the tax from the property that is left. He's not, they cannot go behind him. Whatever property inherits from the person, to that extent, GST dues will be liable. What is personally made by him in his own effort of the legal representatives, that cannot be attached or used. So this should be kept in mind, that this maxim, though was applicable in the previous regimes to a limited extent, it doesn't apply fully to the GST law. The most important maxim that is there and that should be applied is the adi alteram partem rule. Adi alteram partem means no man shall be condemned unheard. This is the most important rule that is being repeatedly flouted in the GST law. Officers do not give a hearing, or officers do not consider your, whatever material that you put before them. Repeatedly, I have seen in GST people, not even the officers, not even listening to what you say. And therefore, the adi alteram partem rule, which is an important rule of natural justice, please understand. One of the rules of natural justice is you should be heard before you're condemned. That is why it says no man shall be condemned unheard. It started, I would say, from several decisions, but one of the leading decisions on this is, of course, the Maneka Gandhi's case, where the passport authority did not give an opportunity for hearing. And therefore, that action of his was quashed. And this important ruling was laid down. The third legal maxim is contemporaneo expositio, est optima et forcima in lige. What does it mean? I may not be pronouncing it perfectly like the legal maxims pronunciation. What it means is this. And this is an important principle which we can adopt. Contemporanea expositio means that when you interpret a provision, you should look at what was the interpretation placed when it was introduced. That's very important. Supposing the finance bill introduces a provision, there is an explanatory memorandum which is attached to it. That becomes contemporaneo expositio. Many times these courts have used such material. Sometimes they have not also used the materials. You have decisions 50-50, both ways. In GP Singh's interpretation of statute, it would be told that this principle is not applicable to the latest statutes, but I don't believe so. I have seen the Supreme Court even now going back to the administrative circulars issued at the time when a statute was introduced and try to understand what was the reason behind introducing the statute. I'll give you an example where I used it. In the case before the Settlement Commission, we had taken a plea that if the tax is collected from the goods transport operator, already he has paid, the question of collecting it again from the receiver of services does not arise, because it would amount to double taxation. And we had relied on a 1997 circular issued by the board. It says, when they introduced the GTA, they said that you should not have, the recovery of the tax should not result in double taxation. So this principle was used by the courts in, saying that, yes, at least in the interim stage, they've given relief. We have to see what finally they accept. But fact of the matter is that we can use some of the circulars which are advantageous to us along with this principle. The next maxim that we will use, very important maxim, and very funnily worded that we may find it difficult to pronounce it. Qui haeret in littera haeret in cortis. He who considers merely the letter of an instrument goes but skin deep into its meaning. What does this mean? Any document, any law which you see, you must understand the intention of the parties and not merely the words. So this is a very important maxim. When you look at documents, when you look at the law, when you look at the rules, you must read it so that you consider the object, the context of the law, and not just only the letter of the law. There are several examples which can be given about this. When I look at a law, when I look at the input tax credit mechanism, is to facilitate, is to ensure that cascading effect of taxes does not happen. Now, anything which goes against that principle will have to be read down. For example, you have the 36.4, Rule 36.4, Rule 86A. If these stand in the way of cascading effect of taxes, if they allow cascading effect of taxes, such rules will have to be read down, and you can use this principle. The next maxim which I will deal with is expressio unius est exclusio alterius. What does it mean? Mention of one thing means you are excluding others. Specific excludes the general. If there is a specific mention of something, other things are excluded. Where is this used? In Singh Enterprises cases, the Supreme Court used this to say that in the excise law, appeals have to be preferred within a particular time period. For example, in GST, the commissioner appeals the appeals before him can be filed within 3 months. And he has a power to condone the delay by another month. So how the courts have been interpreting these provisions? They say commissioner appeals you can prefer the appeal 3 + 1, 4 months maximum. If you prefer an appeal beyond 4 months, such an appeal becomes time barred because the legislation does not permit filing of an appeal beyond this 4 months period. It started from Singh Enterprises cases where the Supreme Court said they use this principle because what they say is the limitation law does not apply. They said section 29 of the Limitation Act will not apply because this act says only 4 months. So you cannot go by section 5 and section 29 of the Limitation Act. If you contrast this with the Arbitration Act, which is there under section 34, it says you cannot prefer beyond the period which has been applied, which has been mentioned in the Arbitration Act. It specifically says and no more. That's what the Arbitration Act says. Supreme Court interpreted that when the term no more is used, that means it is an absolute bar beyond this period. But this kind of a language is not found in our GST Act. And therefore, we must be in a position to fight such cases also. I saw a question popping up in the chat box saying, will it apply for the COVID period? You don't need to worry about the COVID period because automatically there is an extension given by the Supreme Court where appeals can be filed after that. There is no problem. COVID has caused enough havoc. But this one thing, the Supreme Court order under 142 will make this appeal period extended. But you must understand this. If the 4 months expires before the start of March of 2020, that particular date when the Supreme Court order was there, you cannot have the delay condoned. But if it is during this period where the period has been extended, let us assume that you got let us assume that you've got an order last maybe 3 months back. Now the Supreme Court order extending this period of COVID will still apply. Let us go to next two analogous, I would say, but different in actuality, legal maxim, nociter associates and ejusdem generis, two principles that have always been used either in favor of the assessee or sometimes against the assessee by the courts. Nociter associates means the meaning of a doubtful word may be ascertained by reference to the meaning of words associated with it. That means when there is a doubtful word and you have to interpret what it means, you will look at the words that are used in association with it. This typically happens in most of our legislation where 4 words are used and the 5th word, you do not know what it means. This is nociter associates. And many times we find that in several legislation, these kind of doubts come up. How do we interpret? For example, you take 17.5D. You come to 17.5 and you come down to the H clause. Goods lost, stolen, destroyed, written off, or disposed of by way of gift of free samples. How do you read these words? Goods lost, stolen, destroyed, written off, or disposed of. The first thing is, what do you mean by lost, stolen, destroyed, written off? What does it mean? It forms a common genus. Ejusdem generis. That means it forms some sort of a genus. Lost, stolen. Either somebody steals from you or you lose it. Lost and stolen is a common genus. Destroyed. You lost it, not by somebody stealing, but by destruction. Let us assume that you kept raw materials in your stores and there was a fire and it got burnt. That means it has got destroyed. Lost, stolen, destroyed. Written off. Written off means you're not able to use it, so you write it off. These 4 form under a broad category. Category is that you are unable to utilize those inputs. Lost, stolen, destroyed, written off. There is another category. Disposed of by way of gift of free samples. Now this does not come within the nociter associates principle because it is a completely distinct category. It is disposed of by way of free gift of free samples. That means you have got rid of it or you have distributed it free. Now there are 2 ways of interpreting this clause. If you use the nociter associates and say ultimately disposed of by way of gift of free samples means that I have not been able to use it, then it will, all the 5 will come under one clause of nociter associates. That is lost, stolen, destroyed, written off, disposed of. They form under a broad genus. So interpreting this, the courts will be now, when we have case laws which goes up to the Supreme Court, this clause is going to be interpreted whether the principle of nociter associates and ejusdem generis can be applied to this 17.5H or it cannot be applied. Now, if it cannot be applied, then disposed of by way of gift of free samples is a completely different genus. If it can be applied, then disposed of by way of gift of free samples will take the color of lost, stolen, destroyed, or written off. Now, which way the courts will go is something which will depend on how the arguments are led and how the judge will decide. Another legal maxim which is of some importance to us, especially because GST is a relatively new law of 3-4 years. Pari materia. Pari materia means analogous provisions. Analogous provisions means what? Same issue, same subject matter. Same issue, same subject matter. That means to say, if the same provision is there in some other law in the same setting, then that case laws under that law can be used for this purpose. For example, I told you about this 3 months and 1 month limitation period for filing an appeal before the Commissioner appeals. A similar provision was there in the excise law, 2 months, service tax, 2 months, and so many other limitations were there under customs and now even the service tax and the excise law. Now, the single enterprises decision is now can be used even under the GST law to deny you filing of appeal beyond 4 months on the ground that analogous provisions or the provisions of GST are pari materia with the provisions of excise or service tax law. This is one more important maxim or legal maxim which we should keep in mind. Next, which I will deal, of course, is a well-known maxim, non-obstante clauses. Non-obstante clauses are normally used in any act to ensure that that particular provision has overriding powers. If you look at section 16(2) of the CGST Act, it will say, notwithstanding anything contained in this section. That means 16(2) overrides all provisions of 16(1), 16(3), 16(4). Overriding effect. Now, if you have two such provisions with overriding effect, how do you interpret? The interpretation principles will be that the latter will prevail. One principle. Second principle, they will try to harmonize. The first principle is they'll try to harmonize. If the harmonization does not happen, the latter provision will prevail. Supposing one first notwithstanding provision was introduced today and another is introduced tomorrow, it is deemed that the legislature knew that there was already a notwithstanding provision and therefore this, what was introduced tomorrow, will override what is introduced today. This is how the non-obstante clauses will work. But when you have two non-obstante clauses across two legislations, latter legislation will prevail. If they cannot be reconciled, always the courts will see if they can reconcile these two notwithstanding provisions. If they can reconcile, well and good. If they cannot reconcile, then automatically whatever is given whichever is the latter statute will prevail. There is one decision of the Supreme Court in Solidaire Industries which deals with this proposition rather in a very detailed manner. Another maxim which is of some use to us is lex non cogit ad impossibilia. What do you mean by lex non cogit ad impossibilia? It means you cannot be compelled to do something which is impossible. This is a very, very frequently used maxim which can be used in our GST. Supposing the law says, as our input tax credit law today says in 16, that the person from whom you get inputs should have paid the tax. This is hit by the principle lex non cogit ad impossibilia. Why? Because there is no way you can ensure that your input supplier will pay the taxes. It is not possible. How will you enforce it? In fact, in on-quest merchandise decision of the Delhi High Court in terms of the previous VAT law, The Delhi High Court said it is impossible for a person to ensure that his input supplier could have paid the taxes. So long as he is not having any arrangement with that other person, input tax credit cannot be denied, because the person who has not paid the taxes, you cannot recover from him, so you don't give this man the credit. So in my view, this recent spate of amendments that have also been made in 16, which say that he should have uploaded the statement in 2A and that he should have paid the taxes, all this is hit by the principle of lex non cogit ad impossibilia, because there is no way I can ensure. Let us assume I have paid the supplier the money, which includes the taxes. Why should I be denied the credit? And there is no way I can be denied the credit. So this is a very important principle that you can use and you are going to use in the future. These are some of the legal maxims which I thought I will touch upon in very briefly. Now let me come to some of the decisions that are of some use to us. There's a very important decision which I saw of the Gujarat High Court. Sahitya Mudranalaya versus Additional Director General, which I saw. Whether the universities can be brought to tax. Universities which collect, let us say, affiliation fees to colleges, can they be brought to tax? You know that India-wide, many of the universities are getting show cause notices. It's a landmark decision of the Gujarat High Court, reported in 2020, taxman, where Gujarat High Court says education has been exempted. When you talk of educational institutions, it covers not only the colleges, the schools, it also covers the universities. Because you will not be able to get a degree without the university affiliating the college to it. So the word education should be given a very wide meaning. Not only imparting education, but controlling education also falls within the ambit of this exemption. So therefore, I think this judgment is of paramount importance to us. If there is an attempt by the GST authorities to start taxing the universities, as they have been doing to in the service tax regime, to all those institutions which were there. Next decision which I would like to deal with is the Dilip Kumar decision. All of you are aware that exemption notifications have to be read very strictly, said the Constitution bench of the Supreme Court. They went on to say there are two things which we should keep in mind. Taxing statutes, like, for example, the CGST Act, the CGST rules, Finance Act. What is the principle for them? The principle for them is that if there is an ambiguity in the statute, it will go in favor of the assessee or the subject. But this interpretation of statutes does not extend to interpretation of exemption notifications, said our Constitution bench. They said exemption notifications are exceptions to the rule. The logic of the Constitution bench is that if somebody is exempted, the other people bear the incidence of the taxes. Therefore, exemption should be construed very strictly, and if there's an ambiguity in an exemption notification, it should be decided in favor of the revenue and not the assessee. This decision caused a lot of flutter, and in fact, I had commented in my book that this decision is going to cause a lot of problems for other people in deciding cases, because they have not understood the decision fully. tribunals and other courts started blindly applying that decision and saying that's it. If there is, even if there's no ambiguity, they will say it has to be construed strictly and in favor of the revenue. A situation came because, in English, drafting is so poor. It's impossible for us to draft it so perfectly that there will be no ambiguity at all. But a division bench of the Supreme Court now has taken a completely, I would say, some sort of an exception to the Dilip Kumar's case. In Government of Kerala versus Mother Superior Adoration Convent, this was relating to building tax on educational institutions and charitable institutions, which had buildings for housing the nurses and the nuns, I would say. The Supreme Court took a different view from Dilip Kumar's case and specifically said, Dilip Kumar's case has not examined one set of decisions of the Supreme Court, which always said, if exemption notifications have a beneficial purpose, they should be liberally construed. And I believe that this decision of the Supreme Court is absolutely right. Ultimately, an exemption notification should be interpreted keeping in mind whether it is a beneficial notification or otherwise, and what is the benefit they want to give. It cannot be a straightaway denial of exemption on the ground that there is an ambiguity. Ultimately, every exemption is given for a purpose. That purpose has to be looked into. So, in fact, the Dilip Kumar's decision was modified by Mother Superior Adoration Convent, reported in 2021 TIOL. And I believe that this decision is right for the reason that the Dilip Kumar's decision will require reconsideration to the extent that if there is a beneficial notification, it should be construed as such. In fact, Dilip Kumar's decision approved the Woodpeppers Mills decision in 47 AD, which is the correct statement of law. When you construe an exemption notification, at the entry level, it should be strict. But once the subject is found to be eligible, you should interpret that notification liberally. 2 stages is what the Woodpeppers decision said. And it was approved expressly by the Dilip Kumar's case. But unfortunately, in reaching the conclusion, the Constitution bench did not delve into several aspects of the matter. But this Mother Superior Adoration Convent case, I think, sets the clock right to some extent. And I hope that this Dilip Kumar's case will be modified by the Supreme Court in the future to come. One of the issues that has been plaguing us, I would say plaguing us throughout the country, is this provisional attachment which has been being done by the GST authorities. Left, right, and center, they have been attaching bank accounts. They write to your suppliers and say, don't pay this man, pay us. Even before investigation starts, they write. This has become a completely, what I would say, objectionable practice on the part of the department. I'm sorry to say this. So all these matters, in fact, have reached the Supreme Court, where the Supreme Court laid down some guidelines. In Radhakrishnan Industries case, the latest case of the Supreme Court, couple of months back, 2021 TIOL, you will find this decision, Justice Chandrachud's decision along with Mr. Shah, Justice Shah, where the Supreme Court laid down some guidelines when you should exercise the power of provisional attachment. They said it's a draconian power. Please underline this. The Supreme Court itself said it's a draconian in nature. And therefore, the conditions prescribed therein should be strictly fulfilled So before you take action under 83, you should strictly fulfill those conditions. Now, if you look at what the Supreme Court said is this: when the commissioner records his satisfaction that it is necessary to protect the interest of revenue, he should do so when he knows there is no other modes of recovery is possible. So if you have a client who has been filing his tax returns over a period of time, who has been paying his taxes over a period of time, such people, in my opinion, keeping in mind also the guidelines laid down by the Gujarat High Court in various industries case, you cannot provisionally attach the bank account of these assessees who are law-abiding citizens who have been paying the tax and filing returns. If your assessee is of that kind, in my opinion, they can use the decision of Radhakrishnan's industries case. 1. 2. In future, if you go to the High Court, the High Courts are going to call for the files and see why this provisional attachment order was in fact done. Is there any written basis for it? Before the commissioner says provisionally attached, there should be a written basis for it. If there is no basis, then the provisional attachment becomes bad in law. There should be a reason for this man, our commissioner, to believe that this is the only course of action which is available. And for a person who has been paying taxes fairly regularly, filing returns fairly regularly, this kind of provisional attachment is not allowed and should not be allowed. And therefore, the Radhakrishnan Industries decision of the Supreme Court is a step in the right direction to stop the revenue authorities from attaching bank accounts and bringing the business to a halt in a very capricious manner. In correct, in wherever it is required, it can be done. But where it's not required, it may be wrong to do it. Then we look at what I call the other aspect, where the department recovers money during investigation. They record a statement, they come into your client's place, record a statement, recover money. And then say it was paid voluntarily. These kind of cases are going on the rise. I find a substantial amount of cases on this. Suddenly, we had one. In fact, I was listening to one of the matters when I was waiting in the High Court. A very funny matter where they had recovered the taxes at 1 a.m. in the morning. 1 a.m. It's just after midnight. And the Revenue Council is telling the judge, they paid it voluntarily. They used DRC form to pay this. So it is voluntary. At 1 a.m. in the morning, you please tell me, which client gets up to pay taxes? Which chartered accountant gets up to pay taxes? Whom are they trying to fool? It was laughable. The judge himself laughed. But this is what is happening. The good efforts of the government higher-ups is completely spoiled by the lower officers who are operating this law. The ease of doing business announced by our Prime Minister gets completely derailed by these kind of actions taken by the lower people, where during investigation, statements are recorded and completely, amounts are recovered, and then show cause notice is issued much later. And one such case, in fact, came up in Sri Nandi Dal Mills India Limited versus senior intelligence officer. The Madras High Court came down quite heavily and said, whatever is paid during investigation is completely wrong method of recovery. It is not statutorily permitted. And therefore, such kind of amounts one cannot say is paid voluntarily. Then unless a notice is issued under section 73 or 74 and the matter is adjudicated, all these amounts recovered under investigation are nothing but payments under duress. Very important. Very, very important. You can't say that it's paid voluntarily. It is paid under duress. You threaten this person to pay. Therefore, this is another important decision, and that, in fact, the Madras High Court directed the grant of the refunds. They said that we cannot put up with this kind of activity. Refund should be granted to the business. Then we come to an interesting decision of the Rajasthan High Court. HR Enterprises versus State of Rajasthan. Checkpost officers and anti-evasion officers intercept the goods, ask for documents, find the documents are very much in order. Then say, we have doubts about whether the credit is properly taken, or we have some suspicion. We have some suspicion. We feel that the credit should not have been taken, or we feel that the classification is not correct. Detain the goods. Take action under 129-130. Please understand, under 129-130 now, after Finance Act 2021, it has lost its teeth. It's only a penalty proceedings. No more tax and interest can be demanded under 129. Very surprisingly, the officers have been using these provisions to recover taxes. Rajasthan High Court came down quite heavily and said, if there is any doubt on input tax credit, or you feel that there is some issue on that, it should be referred to the regular assessing officer. Anti-evasion and stopping the vehicle is only for checking of documents. E-way bill is there, invoice is there, the matter ends. If you have any doubts, you please refer it to the officer in charge. Very, very important decision of the Rajasthan High Court, and I think I hope that the other people will follow this in the years to come. Then we come to what I feel is an extremely important decision of the Supreme Court in Canon India's case. Canon India's case has been doing a round across the country. In fact, even I have used it to get a stay on the notices issued by the DGGI, the so-called intelligence officers of the Director General. What is this Canon India's case? Canon India's case interpreted section 28(4) of the Customs Act, where it says the proper officer who should issue a notice and adjudicate the claims. In customs law, assessment is done under section 17, read with section 46. Assessment is done by an officer of customs, and supposing you find that goods are cleared, after the goods are cleared, the duty has been short paid. You may find it after 6 months, 1 year, 2 years, whatever it may be, 5 years. Section 28 is a recovery provision, or what they call reassessment. It is called adjudication provision, but I would term it as reassessment provisions. Section 28 says the proper officer can issue a notice. Now, what the department was doing is everybody was designated as proper officer. X, Y, Z, the intelligence officer, audit persons, your anti-evasion, everyone is proper officer. You will clear the goods at Bombay, you will get notice from Calcutta. You will clear the goods at Madras, you will get the notice from Delhi. Some audit officer will issue you notice, you will be answerable, you have to go away. This was challenged before the Supreme Court, saying the proper officer, when it is used, the term the is used, it means only that proper officer who did the assessment. It has to be the assessing officer who did the assessment, not necessarily the same person. It can be any other person who occupies that position. So Supreme Court said, if yes, the terminology used is the proper officer. If you look at 73 and 74, the same terminology used, the proper officer. I took a contention before the Karnataka High Court and I got a stay there where I said the proper officer in GST, how it is to be interpreted. You don't have import and you don't have assessment. Here it's all self-assessment. But there is one important thing that I do. In GST, I file the returns with my jurisdictional commissioner, jurisdictional assistant commissioner. He is the proper officer. He is the man who should issue me the notice. If you want to do reassessment, whom you file the return with, that person should issue the notice. I cannot get notice from somebody in Bombay, Delhi, Calcutta when I'm sitting in Bangalore. Or if you're sitting in Gauhati, you get a notice from Bangalore. Karnataka High Court said at the interim stage, they granted me a stay. Relying on this Canon India's decision, saying only that officer who has jurisdiction over the assessee should issue notices. There is another important principle in this Canon India which we have to argue. There was one decision of the Supreme Court in Saeed Ali's case, which they overrode by introducing section 28(11). This, of course, was not pointed out to the Supreme Court in Canon India's case, but in my opinion, it does not apply. 28(11) may not apply to the facts of Canon India's case at all. The important principle in Saeed Ali's and Canon India's case, which comes in a paragraph, is this: if assessment powers are vested with multiple officers, it will lead to chaos in administration. This is a very important principle that we should keep in mind. If the assessment is left with multiple officers, let us say I file my returns in Gauhati, I pay my taxes in Gauhati. A reassessment is issued from somebody in Calcutta, somebody from Bombay. What the Supreme Court says, it leads to chaos in administration because anybody can reopen any assessment. There is no sanctity to the assessment done. Therefore, I believe that the Canon India's case can be used for the GST litigation and must be used till such time we find amendments being made in the law, or it is quite possible that some amendments may come in the law where they will want to override the Canon India's case, but I have a doubt whether this can actually be overridden.